lawyer. I have my own practice. I do a lot of entertainment, new media law, represent talent, production companies, record labels. So I work in this area. I'm familiar with it. I'm not an academic, so I'm just going to sort of give you an overview of the subject matter and how I've seen it in my practice. So I guess there's a Q&A after, and please feel free to just ask me questions. It's better that way, so I know exactly what you're looking for. Copyright basics. I'm sure you're somewhat familiar with copyright basics. Creation. People always ask me, how do I protect my material? How do I copyright it? You have to fix it in a tangible medium of expression. That's the legal terminology. It has to be fixed in a tangible medium of expression. It can't be an idea. It has to be written, taken as a picture, recorded as music, written down, etc. Protection. You have to register your copyrights. People always say, can I mail it to myself and have it stamped? No. No, you can't. Can I register at the Writers Guild? Yeah, you can, but that won't give you the copyright, federal rules of copyright law protection. Register it with the U.S. Copyright Office at copyright.gov. The rights, what rights does it give you? What rights do you have when you own a copyright? Obviously, reproduction, distribution, exploitation. There's multiple other rights. That's the general rights that you have to really do whatever you want with it. Show it, make money off of it, etc. The term of a copyright varies. If it's a work for hire, if someone has hired you, it's a shorter term. You're the original author, there's a longer term. 70 years after the death of the youngest, the last to die author is typically the term for a copyright. That's the rule of thumb that you want to work with. Copyright. Obviously, there's defenses against the copyright claim. Fair use is sort of the well-known defense. It's sort of an aggregation of 4 elements. Courts generally look at each case individually to see if a fair use defense applies. And again, this is media law. We do film, music, television. When you're watching anything on TV, when you're going to see a movie on the web, these are all the sort of calculations that studio, business, and legal affairs attorneys go through. Copyright creators look at to see if their rights have been violated. These are sort of legal elements, but it's just sort of, it does play into the everyday calculation that all these people make when deciding, do I pay for the rights? Have I used someone's rights without their permission, etc. The fair use defenses, the 4 factors: purpose and character of the use. Why did you use it? Was it a news story? Was it to educate? Was it sort of a not-for-profit motive, or was it solely commercial? Did you just want to make money off of it? The nature of the protected work. The more creative the work is, if it's a Doors song, it's a really unique sort of experience. Well, that has more protection. If it's the phone book, which is a copyrighted piece of material because it's organized in a certain way, that can be copyrighted, and that's really not very creative, so less protection. The amount of protected work used. If you just use a little snippet of a piece of copyrighted work, that weighs in your favor for a fair use defense. If you use the entire song in a movie or the entire photograph versus just taking a little clip, from the side or something to identify what you're using, those are elements that weigh in and out depending on which side of the case you're on. Effect on the market of the copyright. Did your use really take money out of the pockets of the copyright holder? If you sell a CD with full songs of another copyright owner, obviously he's losing money from that. If you're Saturday Night Live and you're making a parody of a Justin Timberlake song, you're not really taking money out of Justin's pocket. Fair use. The DMCA. There's a lot of talk and a lot of focus on the Digital Millennium Copyright Act. It was sort of, our government's attempt to step into the digital age and take all these copyright laws and apply them to what's now digital content. I'm not a fan. I really think they screwed up. I think they screwed up bad. You see what's happening in music, TV's going down. I just think the quality of content is really diminishing because they've created these safe harbor provisions for internet service providers and online service for websites. YouTube, MySpace, you name the site, they infringe all day long and they make a ton of money off of it and the copyright holders get screwed. So I'm not a fan. I think they really screwed up, but that's life. The DMCA, the safe harbor provisions, what are they? What do they do? Who it applies to? Again, ISPs and OSPs. ISPs are the Comcast, the Verizon, the actual cable companies that provide the internet to your home. The OSPs are the online service providers. They're the YouTubes and the MySpaces and the actual websites that really carry the content. And applies to both. There's little tweaks in between the two. Definitions, you don't care about that, trust me. What is it? It's limits of liability. Safe harbor provisions limit your liability for copyright infringement. It really prevents monetary damages and injunctive relief against you, a potential violator, against YouTube, et cetera. When the prerequisites for a safe harbor. Basically, in the safe harbor provisions, they've identified 3 elements that if you're an ISP and OSP, you can find safe harbor by accommodating these 3 elements. Policy of terminating repeat infringers. It has to be in place within your YouTube or your MySpace to, if there is users that just keep uploading copyrighted content, you have to cut off their access and not allow them to create another profile. Designated copyright agent. Any copyright holder has to know exactly who to go to, a name, an address, an email, a phone number, who to go to within your company to say, you are using my copyright, take it down. So a designated agent that's easily accessible by the public. Notice and takedown policy. You have to have a policy within your company that once you receive a notice that a piece of material, a copyrighted piece of material is being exploited on your website, you will take it down. Those are really the 3 sort of elements that have to be within a structure of any ISP or OSP. Right of publicity. It sort of takes a step sideways, and it's another element of law in the digital age. It's not really copyright, but just let's shift gears for a second. It's also known as appropriation. It's in the Civil Code as 3344. Right of publicity is basically it's your right to make money off your name and your image and your likeness. And if you sort of create value in your name and your image and likeness, you should reap the rewards. It's an economic interest versus a privacy or reputational interest. There's a lot of similar causes of action with defamation, false light, invasion into private or public disclosure of private facts. These are all sort of in the same realm of legal claims that you see in a certain scenario, but this one is really sort of, it's not your reputation has been harmed, your privacy hasn't been invaded, you just hadn't made the money off of your name and likeness that you should have. The elements of a claim, obviously use of the name, likeness, or identity without the consent, commercial or other advantage, someone made money off of you, and there was injury to you. Basically, you didn't make the money that was generated off your use. Right of publicity. Right of publicity survives death. Obviously, we know with Elvis' estate and Michael Jackson's estate, as of now, this right survives the death of the person who it was, and there's a huge amount of money, obviously, to be made on the right of publicity. It's transferable as well. You can, by contract, assign your right of publicity to someone else. In will, in the testamentary structure, you can transfer your right of publicity. And if there is no writing transferring your right, whether alive or dead, it will go through the probate structure. If you're familiar with the probate structure, when someone dies, assets go, spouse, kids, parents, it will follow the same structure. It terminates 70 years after the death of the person who originally had it. And you have to register, if you are not the original owner, if you are not Michael Jackson, you are his kids or something, then you have to register with the state that you now have that right of publicity. Fair uses. There are also defenses for, news, public affairs, sports broadcasts. There's a ton of defenses against a right of publicity claim. Obviously, when a network is broadcasting a sporting event, when news is reporting on individuals, those are all fair uses. Obviously, they're still making money off of the uses, but they're not actionable. Licensing and clearances. This sort of brings us full circle to what a lawyer does, or what I would do is, when you need those clearances, when you need to use someone's image, name, likeness, when you need to use someone's copyright, you obviously have to license it or clear it. Generally, copyrights are licensed. Key terms within a license are the medium, territory, and term. The medium, every medium, television, DVD, digital, film, theatrical, they all have to be licensed individually. So if you're creating content, you have a lot of revenue streams to make money off of your content. And if you're a distributor, you need to know what mediums you've now licensed. And territory, obviously, it's generally within countries. U.S. and Canada, South America, all the countries in South America, you can license your right continent-wide, country-wide. There's a ton of ways to different territories to break down, but just know that each territory has its own set of rights that can be licensed and made money from. Term, obviously, how long have you licensed the right for? 2, 5, 10 years, perpetuity. Just beware of those sort of 3 elements. Publicity rights, obviously, if you're creating a piece of fictional content within the talent agreements, you always have the rights to use the person's name, image, and likeness. If they're live sort of documentary events, live concerts, there's always crowd postings or announcements at the beginning of a concert. You will be filmed. We have the right to use your name, image, and likeness, et cetera, et cetera, et cetera. And some quick final thoughts. Find a good resource. Don't sort of use the mother's tales of, oh, I can mail this to myself and it'll be copywritten. Find a resource that you trust, whether it's a book on the subject matter, a lawyer, or someone with experience. Go to them first, because I can't tell you how many times I've had to undo situations that, parties have gotten together, they want to make some content, someone's written something, someone started to film something, who owns what, they don't like each other anymore, what do we do? Jesus. We have to go back in and really sort of negotiate out everyone. Document your rights. When it comes to copyrights, rights of publicity, these type of rights have to be in writing. Transfer of a copyright, use of a copyright is unlawful. You cannot do it unless you have those rights in writing. In writing, they always have to be in writing. Assignment of rights, license of rights, etc. Protection is your responsibility. There's no police for copyrights or right of publicity. You are your own police force. These are your rights, and you have the obligation to go out and make sure that no one's abusing them. So there's no one else looking out for them but you. That's my email. If there's any questions, thoughts, ideas, concerns, just email me, call me. I prefer to just one-on-one let you know, here's what I think about whatever is on your mind. That's the gist.
Thanks, Josh.
Sure.
Are there any questions on this subject? Let's go.
Lots of questions. Josh, when you talked about the fair use, and the less use you have, the more protected you are, explain sampling. You can.
Yeah, music's interesting. Music, there's a specific sort of bar number, and I forget what it is, but if you use over that number of bars in a song, then it's considered a use, a copy, an unlawful use, and is under that number of bars, you can go ahead and use it. Those 4 factors also play in. So it's not only that one factor. If you use just a snippet, then you're fair use. So you really kind of weigh in. In a sampling scenario, there's really you're not making a parody of the song typically. You're really using it for the source that it is, the quality that it is. It's money that really should go to the original copyright holder, because it's not sort of a transformative use. This is really sort of a for-profit endeavor. So those multiple factors weigh in, and I would say that in music it is a little specific because you kind of have to look at the number of bars used. But just one factor, and music's a little specific there.
Any others?
This is actually a bit of a challenge. It may sound like a smart-ass question, but bear with me.
Love it.
I can assume that without safe harbor, a company like YouTube would be held liable for any copyright material that was transported over their service, right? Okay.
Yeah, more or less.
Let's say someone buys a typewriter. They type up a copy of War and Peace. They go out, they sell it. Clear violation of copyright. Would the manufacturer of the typewriter be liable for the copyright infringement? If not, how is that any different from what happens on YouTube?
The direct monetary benefit to YouTube from the copywritten material, I think, it's A to B. Your example was sort of A to X or Z. The manufacturer that makes a typewriter doesn't really benefit at all whatever the author writes on that typewriter. It sells typewriters, but what that person writes doesn't generate more typewriter sales. The content that comes through YouTube's channel directly generates more views, more ad placements, more per clicks, and more revenue. That's the major difference that I see.
On the subject of clearances, so back in the 70s, let's say, when I think it was MTM Productions, Mary Tyler Moore Productions, did a TV show called WKRP in Cincinnati.
Great show.
It was a great show, still a great show, but why don't we ever get to see it anywhere? Because they did not separate the music from the dialogue. The music was running constantly, because it's a radio station, right? So the music's running constantly in the background, and it wasn't mixed separately from the dialogue track.
They have, the licenses are just...
Right.
Yeah.
Now, nobody at that time contemplated a worldwide internet. Okay, so does that mean that somebody has to clear the music for internet distribution of WKRP in Cincinnati? Or even for DVD distribution?
Yeah, it depends. Internet distribution is funny. I mean, with all these safe harbor provisions, a ton of content is online illegally. So it's almost as if, I mean, the purchase model online, I haven't really seen exist yet. There are Amazons where you can order DVDs and have them sent to your house. That's online, but it's still physical, it's DVD. I've never spent $5 and had a digital copy of any movie or any piece of content. Music, yes. And yes, they do have to provide the royalties and they have to have the rights. Film and television, I know it's out there and people are trying it and they're I don't know where it is. Hulu, free TV. You know, YouTube, free TV clips. If someone can tell me, you know, that's my street level experience. If there ultimately were a pay-per-view digital download model, yes, you have to clear those rights. Those are separate rights, but I haven't seen it.
So the distinction, just to be clear, the distinction then is that, forget about the internet because it's too broad of a subject, but if the copyright owner, and the content owner of WKRP in Cincinnati wanted to bring that show out on DVD, they would have to clear those music rights.
Absolutely, they'd have to clear everything.
They have to clear everything, and at this juncture, though, I would think those music rights would be expensive.
Absolutely, assuming.
Because a publisher would see you coming.
Yeah, but it's all, look, a publisher's going to take, you know, something of, you know, some money versus none. You know, they're not going to say, don't use it at all, I don't want to make money. They're going to be reasonable. There's always a deal to be made with people that, you know, to make money. And assuming that when those productions, I guess, like you're saying, when they were filmed and produced and put together, they didn't acquire those rights in perpetuity for all mediums, all territories, et cetera, et cetera. And that's...
Josh, can you talk for a moment about chain of title and how it applies to our industry in terms of a producer acquiring a story? And then, well, let's start with that.
Sure. Yeah, I get that call all the time. You know, I know this person, he has a great story, I want to do a movie about him. There's a script I want to, so yes, that's probably the key starting point in making any film, any documentary. Person, individual, life rights. Sign a contract, get someone's life rights. It really says, you know, you famous, interesting person, you will not sue me for anything. You will help me make this film. I have the rights to use your name, image, and likeness, etc., for this film. General life rights contract. Get a contract with the person you're going to make a film about. Literary material, books, treatments, scripts. Option and purchase. Generally, there's an option and purchase agreement. You can, you know, pay $1 or $10 for a 6, 8, 12-month option on a piece of material. Try and get the funding or a team to shoot it, and acquire a piece of literary material. There's obviously union and guild requirements. The Writers Guild has certain, you know, if you can acquire a piece of literary material from a WGA member, your entity has to be WGA. They can't sell to non-WGA. There's certain price minimums for budgets. If the film is of a certain budget, there's a certain minimum that writer has to get paid for that piece of material. Once you acquire a piece of material, you're really ready to go. You just need to finance your project, which is always the hardest thing in any endeavor that I've seen. Finance your film, finance your documentary, and get work for hires from everyone involved, the director, producers, talent. So once that piece of content, film, television, is shot, filmed, And in a tangible medium of expression, no one in the chain, within the production chain, can claim you don't have the rights to use my image. I made this, so I am also a copyright owner. It's really sort of a full circle of work for hires and rights acquisitions, and then distribution, sell it, make money until YouTube takes it and you lose all your money.
When the producer when the producer hands over the project, the completed negative, to the distributor, and now the distributor takes ownership of that, the proof of chain of title has to go with that product.
Always. Anytime you deliver to a distributor, there's a full delivery binder, really. Every movie that goes to any distributor has a delivery binder, and it's all the documents. It's all the music clearances, it's all the talent agreements, it's all the location agreements, it's the director agreements, it's the production services agreements, excuse me. That delivery binder is the Bible, the legal Bible for that film. And when you do a deal with a distributor, whether with a negative pickup where you make the film and they've already agreed to acquire it, or if you just go make the film first and then try and sell it, you always indemnify any distributor. Anybody that's gonna acquire the rights to sell it, you indemnify them and say, if anyone claims that they have a right, if anyone claims they have a copyright, if anyone claims that their music is being used without permission, I take the responsibility. I will stand up for my piece of work that I created and pay for any lawsuit, pay for any damages. So you better be sure that you have all those rights, because it's going to be real costly and no distributor is going to take it if you don't have it.
So what happened to Watchmen?
Watchmen, that's funny.
I didn't mean that to be a trick question, really.
Okay, so the Watchmen...
Well, I'm not sure everybody in the room knows what I'm talking about. So.
That's funny, though. I was quoted in some articles on Watchmen about what happened in the chain of title. That's why he's bringing that. So, I mean, really, it was just kind of whether greed or competitive juices or laziness among studio lawyers. I don't know if you know the story. So the Watchmen, a producer, I forget the producer's name, 15, 20 years ago, acquired the rights to this graphic novel. Some of you might know. The Watchmen. Brought it to a studio, sold a pitch, basically sold the pitch to whatever studio it was. They went into development. And it kind of got stalled in that studio, as a lot of projects do. It just got stalled. They couldn't get a full script together. They just didn't have the money or the time to deal with it. So it kind of faded. A few years, 10 years go by, 12 years go by. That same producer goes to another studio, I forget who finally put it out. Goes to
Warner Brothers.
Warner Brothers, yeah. Sells the same pitch, the same treatment, the same script. Warner Brothers acquires it, puts 50, 75 million into producing it. It's set to be released, in a few months. This was a while ago. In a few months, the first studio comes back and says, "We own the rights to that. We bought that treatment. We bought that script. We bought that idea. We own the rights to that." They did. It was Fox. Fox had purchased it. They had the rights, and really sort of, so for no, Warner Brothers ended up coming out of pocket a great deal, and Fox really just didn't have to do anything. They just sat back and made many millions.
I think the settlement on that was that Warner Brothers had to share a portion of the domestic distribution.
Yeah, it was something like 30 or 50% of.
Yeah.
This happens all the time, that one studio buys, they don't want to make it, they just shelf it. It goes into turnaround. It can be purchased back by the original person that sold it. So there's a lot of things that go in development that are sold that are ultimately bought back. But there's a knowledge of that process, and you have to sort of do your due diligence as a studio head, as business and legal, to say, has this been bought back? Who ultimately owns it? And I will say the paperwork can get real sticky, and you never know what you're dealing with. But I don't know what the final numbers are for Warner Brothers, but they may have still made money. And just, that's, when it comes to business and legal decisions like this, ultimately it turns on what's it worth? What's the potential cost if I don't? And what is it going to cost if I do? It's really kind of a business decision ultimately. And you want to, copyright claims, things like statutory claims like these are very expensive. So you really need the rights.
The conversation has been a lot about from the entertainment industry into digital, looking at it from the other way around, from people who are creating digital content that is now getting more and more complex in terms of intellectual property that's going out not just as writing, but then as audios, as podcasts, as videos. What is the proper way? I mean, really, any one of us can grow into our own multimedia studio. I mean, any one of us can be Rupert Murdoch, only hopefully with better politics. But for people who are working in that arena, what is the proper way when content is being generated so quickly and in such volume to protect ourselves so that anything that is proprietary to us, yeah, there's a lot of stealing on the internet, but at what point do we copyright a website, a video, a something? Do you have any perspectives on that?
You know, as soon as possible. A copyright is created, like I mentioned, as soon as it's fixed in a tangible medium of expression. So you do have an existing copyright once that website is created, once that picture is taken, once that song is recorded. You do have a copyright, and you own those rights. You're just not afforded the protection of the U.S. copyright laws unless you register. And those protections are very good. And there's a lot of the statutory damages that infringers are forced to pay. You want to register to access those. So your copyright is created immediately, and you own that. There is no major rush. It's always best to get it done. Like I said, that your copyright is created from inception. You're right, with digital, exact copies of whatever you make can be created instantaneously. So your best, there's no protection. I mean, really, now these are the problems with these safe harbor provisions in the DMCA and sort of this laissez-faire attitude towards, commercial infringement that is just rampant. And content producers and content owners are getting destroyed. You see the music business, it's getting destroyed. TVs turn into crap. But, just content owners, film will be next. So, back to your question, your right is created immediately. Register as soon as you can. But the best protection, I'd say, is to really get your product out there and try and be the one to make money off of it before it gets stolen and other people do.
Josh, could you do a minute or two on droit moral?
It's funny. So creators of content have what's called moral rights, and the droit moral is the French terminology for it. So you have moral rights. It's sort of an old school concept about, I created this, it's my heart and soul, and if you change it, if you alter it in any way, it's a moral claim by me. And so always, a lot of pieces of content, when they're sent to other territories or exploited, with other languages or cut into other forms, there's a moral right that is potentially breached by these adjustments of a piece of content. And typically a distributor, any studio is going to require that you waive your moral rights and the changing of your content, because we need to do it to sell it in France, and we need to do it to sell a different version in Japan. So any tweaking is now what, that's the essence of your moral right, and the beauty of what you created is, well, money now trumps, and screw it, we're going to change it.
But moral rights are negotiable in the United States.
For all the deals that I've done, they're just waived. Content creators, talent, producers, directors, you just waive them.
Well, what I'm getting at is the idea that in France, for example, I can't go to an actor and say that their performance, that I own their performance, get them to sign a contract, I own their performance in perpetuity in all media throughout the universe. They'll sign it, but actually they're not really giving me anything under French law.
Yeah, there is distinctions with how those rights have to be transferred or waived in writing in the different territories. Absolutely. And in all the U.S. contracts, you include, it's really cut and paste at this point, but you include that version of a moral right waiver, that sort of European version within the U.S. standard contract. So you're right. I mean, there are different terminologies for how it has to be waived.
Right. And I think to kind of put some punctuation on this, and I'm sure everybody in the room already know this, but U.S. copyright law is not copyright law for the world.
No.
There are distinct differences and major differences that cause us problems that affect piracy, for example.
Yeah, we haven't. I mean, I haven't. I started my career litigating, and I got out 4 or 5 years ago because I hated suing. So I only do transactional work. So at this point, we haven't. I haven't had a plaintiff's copyright claim in 6 years, and I haven't dealt with internationally. If there's always, for my clients, it's always a domestic claim. Our distributors are domestic. You go to the Weinstein Company, you go to Disney, they're here. You say, hey, but yes, it's a U.S. copyright structure. There are conventions, there are treaties and conventions that sort of dictate that, there are certain aspects of various countries' copyright law that will be respected in those other countries that are parties to those treaties. It's a complex network of or patchwork.
That's the Berne Convention.
Yeah, the Berne Convention is really the one that.
Right. And but the idea that, if you do something in the United States and you have registered and you are covered or protected by the U.S. Copyright Act doesn't necessarily mean that you will have that same level of protection outside of this country, correct?
And China, for example.
China, for example.
They don't even bother at all.
No.
No. It's fine. Yeah.
Any other questions at all? Oh, here we go.
Hi, my name is Madeline McBride. You were talking about chain of title, and somehow or another you concluded that lack of appropriate chain of title has resulted in television being, as you said, crap. I got lost somewhere in that chain. Can you elaborate?
Totally my fault if I blamed chain of title for the crappy television. But let's agree that television is crappy. Okay. It's piracy. The Digital Millennium Copyright Act, which created these safe harbors for online service providers, has really drained the money. Internet is good, there's a lot of people going to it, but the money that was generated from a copyright owner has really diminished. Music was the first casualty because of the size of the files. Television is coming, at Pirate Bay, any of the major pirate sites, you can download full half-hour, 22-minute versions of any television show. So the money that these studios can make in different territories and even domestically is just decreasing. Obviously, there's ad revenue issues and just more choices for the consumer, but music was the clear example of if you let people pirate your copyright, that industry will suffer dramatically.
I think the idea is something that one of our other speakers was talking about, which is if you diminish the value of the Windows system over time, then the amount of money that you have to finance new content will go down. And that's the case, certainly of the music industry today, but it's also the case of the television industry, which, I don't know why, but we always kind of talk about television last, But the television business and the production of television product is enormous. And there's a lot more trucks rolling around Burbank, with television crews than there are film crews.
And yeah, absolutely. And I think, it's newspapers. They're going to go the way of the newspapers. And newspapers were sort of riding. TV had a certain amount of ad revenue, and their production costs, just dipped under that ad revenue, and so they had a nice margin. The ad revenue is decreasing minimally, and so what they've done is they've taken the cost of production and exponentially decreased it with all this reality crap that you're seeing on TV to really keep that profit margin so people could keep earning their money, keep earning their pitching. Eventually, that ad revenue is going to diminish to the point that there's just not enough money to make content that's worth anything on television. It's going to take time, but that's a discussion, that's sort of a business discussion on another level, but it's going that way.
Hi, my name is Yvonne, and I wanted to ask a question dealing with reality shows. I wanted to know what is the extent or level of rights of publicity for a contestant in a reality show, and how does someone protect their rights of publicity, if they are any?
That's a good question. If I showed you the contracts that those reality TVs give their contestants, I hate looking at them. Those are the thickest, most verbose. Anyone on a reality show has basically signed over everything. In addition, not only have they just waived every possible claim and given every possible right to the network, typically now, if that contestant does anything outside of the reality show, now they're famous, now they want to write a book, now they want to go speak, that network will take a percentage of whatever that person now does after the reality show. So not only do you have no claims whatsoever in that reality show, you are now giving up a percentage of your income from whatever else you do. Those deals are bananas.
In terms of the stuff that they do afterwards, as you mentioned, books or printed material, does that have to do with in association to do with the reality show that they featured in, or anything that they do whatsoever?
Anything. Well, anything. How the contracts are typically presented first, they'll take 5 to 10% of anything ever that you do, like till your grandkids die. But you can knock out. I had a girl that this show really wanted. We got that entire provision kicked out. You get nothing of anything else we do. You really want her on the show, take her. So you can get things kicked out of those. As far as the actual show is concerned, nothing. You have to waive all claims. You've given all rights to the network or production company to do anything they want with that show. Period. You may get those other revenue streams that they want a piece of. You might retain those, but as far as the shows, write-up publicity, they can do whatever they want.
I'm wondering if there's any way to protect material that, let's say you're writing a proposal and you put forward a series of ideas, and then the person you propose them to takes your ideas and hires someone for 50% less and realizes them. A, is there any way to protect your proposal as you submit it? And B, is there a way to do it without alienating the receiver?
Proposal as in like a business proposal? Or?
Maybe it's a proposal for an ad campaign. Maybe it's a proposal. It's something that's very specific, though. You do this, you write this, it's got this copy, it's got this image.
Well,
or you follow this strategic plan.
Yeah, if it's a plan, if it's sort of a plan of action, there's nothing you can do to prevent someone from executing on that plan of action. If it's an ad proposal, if it's actually the creative, the visual concept, the verbal concept, those are protectable. And once you've written them, you own them. Whether you want to sue a potential client or not, obviously, I hear your concern.
How do you let the person know on the other end when you're submitting the document that this is copyright information? Do you just put,
whether you let them know or not, you still own the copyright. Yes, you can put, you can put the little C on top if you want. That means it's a registered copyright, but if you're just trying to get the point across, like, hey, I own this, don't do anything with it, it can really come in any form. This is copywritten material, I own the copyright, created by a lot of times with scripts are submitted all the time. Written by Joe Schmo, date. That's sort of noticed, like, I wrote this, I created this. You don't have to put copywritten, it doesn't really, those are just sort of, whatever flavor you feel conveys the style that you want to let people know that you own it, it can be multiple different ways. You see what I'm getting at? Mm-hmm.
Referring to the woman's question in the back with regard to business plans, of what value, if any, is a confidentiality statement that the person who receives the business plan signs, and then you receive the plan back when they're finished reading it if they don't choose to act on it?
In my experience, none. They're only as good as the willingness of a party to sue. That's it. I mean, are there rights created in the confidentiality? Absolutely. Someone can't go discuss with other people. If it's your idea and you haven't executed on it quick enough and someone else does, do you want to spend the next 3 to 4 to 5 years and the next $150,000, $200,000, $250,000 chasing down what you should have just done or wished you did? That's really that's how valuable it is. You know what I mean? To sue on a confidentiality, to prove it, what are the damages, how much money do you want to spend chasing down something, you might as well move on to the next project and just do it and get it done.
Almost a waste of time putting it in there and could actually just alienate the person who's receiving the plan? They're in deals all the time, and I sign them all the time.
and they just don't mean it, I don't care. I mean, they just don't mean, you know,
Okay.
if someone really wants to sue me, prove it. Prove that whatever third party made something, it came from me. And B, do something better with your $300,000 in your next 3 years. So I don't think you risk alienating someone by having it in there. And I think for those people who really maybe don't spend their days in law, it may provide sort of a, oh, wait, I can't talk about this. I signed a confidentiality. So it may have some effect, but it really comes down to if someone breaches it and something happens, what are you going to do?
Anything else? All right. Thank you very much, Josh.
Thank you.